The Supreme Court decision in the case of Marcelino Dela Cruz, LINGGANAY versus Del Monte Land Transport Bus Company, Incorporated and others. In his own narration of facts, LINGGANAY admitted that he was involved in several vehicular accidents. He said that on October 21st, 2013, while driving DLTB passenger bus, he met an accident involving one Isidro Alvarez. LINGGANAY did not mention whether Isidro Alvarez was his passenger. Hence, we deduce that he must have been a third-party pedestrian. This vehicular accident case was settled out of court. We know from experience that an out-of-court settlement, especially one involving a physical injury claim, involves payment of financial indemnity to the injured party. On May 15, 2015, LINGGANAY committed the violation of overtaking a double yellow line at Carmel Ray intersection, Barangay Tulo, Calamba City, for which he apologized to the management when asked to explain for the incident. On October 8, 2015, he failed to take time schedule. Hence, he was suspended for 5 days on November 5, 2015. On December 30, 2016, LINGGANAY, while driving DL 550 along the National Highway, Tagawayan, Quezon, hit the rear portion of a Mitsukoshi Hari motorcycle, causing damage to the motorcycle and slight physical injuries to its driver Aries Seep and the latter's backrider Dave Joseph Del Rosario, who were taken to Tagawayan Memorial District Hospital. LINGGANAY was detained, including the bus he was driving, at the police station, and they were released from the police custody only when the parties involved executed a casunduan before the municipal mayor, whereby LINGGANAY agreed to pay the damages to the motorcycle as well as the medical expenses of the injured parties. The last vehicular accident of LINGGANAY was on May 1, 2017. The evidence disclosed that LINGGANAY was driving bus DL 551 along San Juanico Bridge following a Toyota Wigo. LINGGANAY alleged that a van overtook them and cut the path of the Toyota Wigo. The Toyota Wigo was able to stop on time and thus avoided bumping into the rear portion of the van. LINGGANAY, however, failed to stop and bumped into the rear portion, the Toyota Wigo. Investigation likewise disclosed that LINGGANAY was at fault for being reckless in his manner of driving the bus. LINGGANAY, right out, made an initial payment of 5,000 pesos to the owner of the Toyota Wigo. This act of LINGGANAY indicated his fault and willingness to settle the damages to the Toyota Wigo. The road where the accident occurred was descending or pababa, and the complainant did not keep safe distance from the Toyota Wigo. LINGGANAY also claimed that he was not driving fast, but this is belied by the extensive damage to the Toyota Wigo, indicating a strong impact by a fast-moving vehicle. In fact, the owner of the Toyota Wigo claimed damages in the amount of 99,000 pesos, which respondent DLTB company paid in exchange for the deed of release, waiver, and quitclaim executed by the owner of Toyota Wigo. The DLTB company passenger bus likewise sustained damage in the amount of 6,500 pesos. Indubitably, the past infractions of LINGGANAY not only repeatedly endangered the properties, safety, or lives of his passengers, the pedestrians, and the riding public, they likewise exposed respondents to various liabilities. Still, LINGGANAY insists that even if he was indeed negligent in the performance of his tasks, it was not shown that his negligence was both gross and habitual, that while he was previously involved in some accidents, his past mishaps were merely minor. Thus, LINGGANAY avers that the penalty of dismissal meted on him by respondents was too harsh. In the case of LBC Express Metro Manila Incorporated versus Mateo, the court held that an employer cannot be legally compelled to continue the employment of a person who is guilty of gross negligence in the performance of his duties. An employer cannot legally be compelled to continue with the employment of a person admittedly guilty of gross negligence in the performance of his duties. This holds true especially if the employee's continued tenure is patently inimical to the employer's interest. To recall, the infraction of LINGGANAY, which prompted respondents to ultimately dismiss him from employment, was his recklessness when he crashed into the rear portion of a Toyota Wigo that caused substantial damage to the car in the amount of 99,000 pesos and to the company bus amounting to 6,500 pesos. To avoid any possible legal suit against the company, respondents were compelled to pay the full amount of 99,000 pesos to the car owner. Indubitably, even assuming that LINGGANAY's gross negligence was not habitual, the damage and loss caused by his last infraction to the company was so substantial that respondents indeed cannot be legally compelled to continue his employment.